Hi guys, let me start off with a quote before I talk about the new law marathon for CA Inter. What I believe in is revision isn't about perfection. When you revise, don't expect to be perfect. It's about progress. When you keep revising, you will progress, and that progress will lead you to perfection. So keep revising, guys. Keeping that in mind only, and keeping that we have just 10 days left. I am releasing a new law marathon, brand new law marathon for CA Inter Jan 25 exams, May or September 2025 exams. Part 1 is this. Sir, what is this marathon all about, sir? Very simple. We are going to basically cover 7 out of 15 chapters in this marathon in just 90 minutes, and we will be covering 50 marks, 50 in 90 minutes. Sir, what are the chapters that we are going to cover in this part 1 video? Audit and auditors, charges, dividend, prospectus, then accounts of company, meetings and FEMA, as you can see it on the board. Sir, what is this? Is this different from your regular marathon? Regular marathon is also there, guys. I will call this Gen Z revision part 1. Sir, what do you mean by Gen Z revision? For example, I have now taken Gen Z notes for charges chapter. In our class, we summarize a full chapter in just one page. That's it. Full charges chapter from here till here. That's it. We will revise. Using these notes, I will do the revision of Gen Z chapter of charges over here. I call it Gen Z in our class. So that's what we use the term Gen Z, because it has to get over fast for you all. So like I said, 7 chapters out of 15 we will do, which will cover 50 out of 50 marks in 90 minutes. Sir, I want the full marathon of law. Is it available? Yes. The full marathon already has about 75,000 views on YouTube. The full law marathon is for 12 hours. Detailed marathon. Students have studied only this and easily got 50 or 60 in exam. The full marathon will detailed cover 75 marks, but this is a much faster version of the marathon. That's why I call it Gen Z revision. In the link, you will find 3 things in the link in description of this video. The first thing that you will be finding is the Gen Z notes. Second, I will give you link to the full marathon. To the full marathon link will also be given. And third, even the relevant material links apart from Gen Z notes for full marathon material also will be given over here, guys. So watch this Gen Z marathon. We are going to quickly revise all the limits that we have in FEMA. Gen Z notes of FEMA, guys. Basically, except for residential status in FEMA, we are going to revise the whole of FEMA in the next 10 to 15 minutes max. Basically, if you see, there are 7 dabbas that you have to remember, or 7 different types of limits. First is current account, which is schedule 3. Current account has totally 3 schedules. The third schedule talks about what you can do as an individual. For that, as an individual, limit is 2,50,000. If it crosses that, then you will go to RBI. This 2,50,000 is for what things? Like gifting, for donation, for any expense of medical, education, private tours, tourism, all of that if you want to go abroad. In that, they are not giving you 2,50,000 if you go to countries like Nepal and Bhutan, because you can use Indian currency itself. In this list, specifically they are saying for immigration, medical treatment and studies. For these 3 things, if it crosses 2,50,000, please get a confirmation letter from the respective institution also. Now, this 2,50,000 is for one individual. When I go with a group of friends or family, can I group it? Yes, friends, family. Same if you go together in the same visa or you can group it off, guys. Okay, that is about schedule 3. These are the key points. Other expense of schedule 3 could be, for example, you are buying mobile from US. Okay, you can buy mobile from US. It should be within the limit of 2,50,000. Are you following, guys? Clear? I'm not capitalizing mobile, keeping it in the expense side. Next, Again within current account, schedule 1 is prohibited. That means current account has 3 schedules, guys. If you look at the 3 schedules of current account, should you remember these numbers? Yes, I will tell. Yes, okay, easy to remember, nothing great, it's easier than section numbers. What is schedule 3 of current account? Which you can do, allowed, permissible. Can do means permissible. Okay, next schedule 1 is cannot do, prohibited, no permission, nothing, you cannot do. Schedule 2 is you can do with the permission of central government. Schedule 3 is can do with the permission of RBI. Are you following? Within schedule 2 you have two types. One is for individual, one is for other than individual. What we finished so far is other than individual. So we are individuals. We are done with individuals for schedule 3. Next is current account schedule 1 prohibited. These things not allowed. Remittance out of lottery winnings. All lottery winnings in India you can't remit out. Race horse winnings. Riding horse from India, money can't go out of India. Money can't go out of India. Remittance for purchase of lottery ticket outside India. US lottery, no. For abroad, then banned and prescribed magazines you can't buy. Football pools and sweepstakes outside India you can't buy. Next, this same list has few other things. You have to search for these terms. Now I'm not focusing on logic in detail class. Here, callback service, dividend balancing, commission on export on equity investment of wholly owned subsidiary in India, special rupee scheme account. These are all in schedule number. Which schedule, guys? 1 which you cannot do, current account. So out of 4 dabbas that we have in current account, 2 we have revised. Are you able to follow, guys? Okay. Next, one more point we missed here. Commission on exports up to 10% of invoice value for tea and tobacco. Usually you can't pay commission on exports, but if it's for export of tea and tobacco, allowed up to 10% of invoice value. This also is what in cannot do, with one exception. You can do up to 10%. Clear, guys? Next I'm going to current account schedule 2. Schedule 2 of current account, which is generally for the government departments, PSU, institutional level, government, usually for government departments or government things. Central government you have to get approval for all of this. Cultural tour. Is there any limit for cultural tour? No. Cultural tour you have to get limit approval. Cultural tour. Freight of vessel by PSU. Then that means renting of ship by PSU. Import by PSU through ocean if there are some expenses. Multi-model. Here again code word. Multi-model. Then container detention and payment of PNI club and transponders. Are you able to follow, guys? For this we had that story also. Indian team going to West Indies. That ship, signal, all container, all that is done. In this central government approval, apart from these code words, multi-model, container, all of that, okay. 2 points have limits. So you have to remember this for sure. If it's for payment to foreign print media by public sector undertaking, you have to see, is it for the following set purpose: tourism, foreign investment or international bidding, then it is exempt. Others na up to 10,000. So if PSU is advertising for 3 purposes: tourism, foreign investment or international bidding, then allowed. Beyond that, others up to $10,000. Prize money for sponsorship for sports that happens outside of India. Any state or national or international body of India is conducting cricket tournament, badminton tournament, whatever tournament, there is no. Apart from state, national, international, private is conducting, up to $1 lakh is allowing. $1 lakh into 80 is close to 80 lakhs. Ada tandi agu for keeping cricket tournament for private company. So they are allowing up to that much. Are you following? Now we are going to schedule 3, current account other than individual. So if I come back to this diagram over here, now we have finished revising schedule 1, what you cannot do. Schedule 2, central government is done. Schedule 3 we have finished with individual. Now we are going to schedule 3, can do with RBI permission for other than individuals. In other than individuals there are only 4 points, and all these 4 are important limits. Okay, I told there are only totally 8 limits in this act, correct? Only 8 limits with some schedule numbers. You can't remember this. If you look at the past exam question, this only they are testing. These limits will come for 4 or 5 marks. Now, commission to an agent abroad for sale of residential or commercial plot in India. So let's say you're selling residential or commercial, your house in India is purchased outside. For that, for agent commission is $25,000 or 5% of inward remittance, whichever is higher. Logic is more higher, more commission you will get. Consultancy for infrastructure up to 1 crore, $10 million. Others 10 lakh, $1 million. Following, guys, clear? Next, reimbursement of pre-incorporation expenses, that is allowed up to 5% of investment in India or $1 lakh, whichever is higher. This you have to mug up, but the logic you know, why higher, why lower. Last one is a new point, donation. Very, very important for exam. If you are donating for 3 purposes, code word chairs for chairs over there, or funding of educational institutions or any funds for educational purpose, or technical institution for research in the same field of donor company, then in that case it will be 1% of forex earnings of last 3 years or $50 lakh, whichever is lower. This ends our current account, 4 dabbas. Not that difficult to remember, correct? Half an hour before exam you go through that, 1.5 day you can revise. Now coming to capital account, much more easier. What is capital account definition? We saw capital account is basically a person resident in India alters asset, liability, contingent liability outside India. Person resident outside India alters asset, liability in India. For that, examples only are in schedule 1 and schedule 2. Not that important in capital account, that's why we didn't write here. Meaning simple, fairly easy list. Giving loan, taking loan, buying asset, selling asset. In schedule 3 there are some prohibitions. That is more important for capital account, because things to remember. North Korea, can you enter into transaction? No. Who has to give permission? Central government. If you enter into transaction, buy asset, sell within 180 days. Then for a PROI is prohibited to invest in India, even though we are getting forex, chit fund, nidhi, agriculture and plantation and real estate, TDRs. You can't invest. TDRs is transferable development rights. But the word real estate does not include this. That means these things are included. Commercial and residential flats you can invest. Real estate infrastructure trust you can invest. Township, roads and bridges they can invest, because that is for development. Otherwise, how will we develop? These are basic developments that are needed. Lastly, some miscellaneous concepts we saw, where apart from the limits, apart from residential status, what to remember. In reverse, if you see this account like RFC, resident foreign currency, or EEFC, exchange earners foreign currency, balance will be in dollars. These are exempted from FEMA because it's in dollars. Next, if any foreign national is working in India and getting salary, he can take the money and go abroad. Remittance of salary of non-resident working in India for the job should be maximum 3 years, but Pakistan means you can't take the money. Then under definitions, foreign exchange definition, you know what is foreign exchange. Balance in bank account in foreign countries. Ada Tandi, he is saying any instrument like traveler's check or bills of exchange drawn in India but payable abroad, payable in dollars, or drawn outside India in dollars, payable in India in rupees. Between the two things, where it is drawn, where it is paid, any one should be abroad. It should be in dollars. Then also we call it as foreign exchange. So these are the concepts in FEMA. Quick revision, except for residential status and related point of PRIA and PROI. Are you able to follow, guys? That's all you have to remember for exam, guys. Thank you. Now, how to revise prospectus from your GenZ notes, guys? This is the prospectus GenZ notes that we have. Same order what we did whole day. See if you're getting the clarity. Okay. 2 subsection 70 talks about prospectus is defined as anything which is described, document described and issued as prospectus. Notice, circular, advertisement where you are getting offer from public and includes rendering prospectus, shelf prospectus. Exam oriented, what to remember. Repeat with me as loud as possible, just 5 minutes. Next we went to section 32 which talks about rendering prospectus. What is rendering prospectus? Where quantum of shares or price per share is not mentioned. What are important over here? File to ROC 3 days before opening of offer, and after closing of offer, if there is any difference, you will again file that to ROC. Next, the shelf prospectus. What are the key points? Shelf prospectus is valid for
1 year from the date of first offer, then during that 1 year you can have any number of issues. For that you have to issue an information memorandum maximum 1 month before issue. That at least 1 month is the wordings used. Then what will it contain? Material information, details of charges if any. Calls in advance is allowed, refund within 15 days if they ask for the same. Are you able to recollect the points, guys? Exam only this. Don't be like IO shelf prospectus, infrastructure company, metro. No. Exam only this. Next, we went to section 27, which talks about variation of terms of use object. For that 5 points. First, special resolution in postal ballot, then explanatory statement, website, newspaper, exit opportunity to dissenting shareholders. You can see and tell, guys, exam is long way there. Next, 29 we saw is demat. In demat, all shares have to be in demat. If it's not in demat, you can't issue. No rights, no bonus, no buyback. Yearly, you have to pay fees to depository. Security deposit should be given for 2 years. PAS 6 should be filed within 60 days of end of the half year to ROC. Who will sign? CA or CS. Reconciliation, grievances. Are you able to follow, guys? Are you able to recollect all the points? Next, 39 we saw allotment of shares. Here, minimum subscription 90%. Minimum application value 5%. Now, 5% of nominal value. Correct. Money should come only in banking modes. Subscription should be received within 30. No. Okay, see, so RHP is filed before 3 days, that we saw in different provision. From date of filing prospectus, you receive money within 30 days. Once offer is closed, if money is received less than 90%, it should be refunded within 15 days with interest of 15% from the 16th day. Next, if money is received more than 100%, also the excess should be refunded within 15 days. That 100% you should allot within 30 days. Are you able to remember all of this, guys? Okay. Next, section 40, application to be dealt with stock exchange and underwriting. First, you make application to stock exchange. If they don't give approval, money has to be refunded. Can you have any complaints or any complaints waived saying no, I will not follow? No, such provisions are void. Then prospectus should have the name of the recognized stock exchange. Then that money should be kept in separate bank account. If I apply for 3 stock exchange, you need to get approval of all the stock exchange. Any one doesn't give, full allotment is void. Underwriting, only 3 points. Shares percentages 5% or AOA, whichever is less. Debentures 2% of AOA, whichever is less. For paying underwriting commission, I can use profits or proceeds from issue. Online, I want you to repeat with me, guys. Keep repeating. Prospectus should also contain name of the underwriter. For underwriting, what should authorize? Articles. AOA should authorize. Then we went to lunch. Then we came back from lunch. Then we saw criminal and civil liability. 34 is criminal liability. 35 civil liability. 36 class action suit. 37 is class action suit. 36 is personalization. 34 is simple criminal liability. If there's any misleading statement or any omission which is material, you are liable under section 447. If it's immaterial, defense if it's immaterial or you believed it to be true. You thought that immaterial thing is the material thing which was lied. You thought it was believed to be true. 37 is simple. All persons who authorized issue are liable to the person who suffered loss. If fraud is involved, liability is unlimited. 37 also has a few defenses. In simple, you did not know about it. You thought it was true. Once you knew about it, you took effort to withdraw your consent. If you knew about it after prospectus is issued, now you gave public notice. That's it. This is 35. 37 is what? Class action suit, nothing great. In 36, we just have 3 cases where if you are giving wrong information, deceitful information, concealment, liable under 447. What are those 3 things? 3 examples. Underwriting commission, then profit from sale of shares, price fluctuations, and obtaining credit facility from bank, giving wrong information and obtaining. 36 is done. Then again, last 2 sections, 25 and 28. 25 is deem prospectus, where a company is giving shares to allottee, through allottee giving shares to public. Such an agreement is called deem prospectus if 2 conditions are met. The allottee is giving shares to public within 6 months, or allottee has not paid full consideration to the company. Super. Offer for sale, nothing great. Existing shareholders of company selling shares to the new shareholders For that, some provisions like 3940, 90%, 5%, allotment, application to stock exchange, underwriting, all these are not applicable. Some other provisions like 26, contents of prospectus, 34, 35, 36, 37, criminal, civil liability, punishment and class action suit are applicable. Any expense incurred should be reimbursed. That's it. Are you able to follow, guys? Perfect. Okay. Yeah, clap. Okay. That's it. So what is left at this point in this chapter is basically private placement under section 42 and few not there sections which I told 24, 30, 33, 38, 41, which we will do tomorrow later. These are all private placement important. Those 5 sections, 5 minutes. That's it. Thank you guys. See you after the break.
Hi guys, now quickly let's revise charges chapter from section 77 to 87 using our GenZ notes within 10 minutes. So charges in 10 minutes. In this chapter, the first important section is section 77, which talks about duty of charge holder to register the charge. Here if you see, there are only 4 core provisions. First, register the charge with prescribed fees within 30 days from the date of loan. Next, if you don't register within 30 days, in the next 30 days, you will register by using additional fees. Next 30 days also, if you don't register, then they have given you the next 60 days with ad valorem fees. This is something everybody knows. So the rule is 30 plus 30 plus 60. Second, if there are multiple loans and multiple lenders have to register, whoever registers first. Concept is whoever registered first has right over people who have registered subsequently. So what happens to the loan if you don't register? Concept, non-registration makes the loan as an unsecured loan. That's it. If an asset under charge is sold, then the new buyer of that asset has to again register the charge. In case the property is outside of India, we will have verification on different basis under the hand of the charge holder or director or company secretary of the company. In our class notes, we categorize them as A, B and C. Okay, next section 78 gets activated when 77 is failed, 78 gets activated. What is this? Where the charge holder will register if company fails. So for example, if the company is not registering, Vijay Mallya, Kingfisher took a loan, they are not registering the charge, then the charge holder, the bank will register the charge. When they will register, usually they will wait for the first 30 days. If nothing happens in the first 30 days, so after that first 30 days, the charge holder will intimate ROC for registration. He will send a notice who the ROC, once the charge holder, the bank tells ROC we want to register this charge, the ROC will send notice to company and wait for 14 days. Why he will wait for 14 days? In these 14 days, the ROC will see if there is any objection coming from the company. If no objection comes or if the company remains silent, then ROC will proceed for this registration. So this is section number 78. Next we will go to section number 79, where 79 talks about modification of charge. What is modification of charge? Okay, yeah, hold on. Now next is 79, which talks about modification of charge. Yeah, in 79, which is modification of charge, what we learn is, one second guys, hide this scale, I don't know how it came. Yeah, don't count these few seconds for the 10 minutes. Modification. Once you register a charge, if you are making some changes like change in interest rate or change in terms and conditions or change in repayment schedule, 5 years you are making it 7 years, interest rate 10 is becoming 12, partial release, you took a charge on a house, ground first and second floor you're releasing, or increase or decrease in limit of loan, 10 crores you're making it 15 crores, or making the charge as a pari passu, making all the parties equal. If this happens, you have to intimate ROC within what is the time limit? Same time limit of section 77, 30 days and 60 days. Okay, Here, what is important to note, I'm sure you have been waiting for that. In change in interest rate, you don't have to intimate ROC if it's a change in bank rate. Sometimes bank changes the rate for everybody, that you don't have to intimate. Or whenever you are changing the limit for a working capital loan, that working capital loan we don't have to intimate to ROC because that is not taken as a modification. Going in the same order, we are done with 77, 78, 79. 80, another important question many times came in exam, which is date of notice. Whenever a charge is registered, section 399, which talks about public document, it is deemed that everybody transacting with the company have a doctrine of constructive notice, that they are aware about the charge which is registered with the company. Therefore, third party is deemed to be aware of the charge. Tomorrow, third party cannot tell, we did not know that charge was there against this company for this loan or against this asset. Next, 81 and 85 are new additions in new syllabus. Both 81 and 85 talks about maintenance of register of charges. That's it, as simple as that. 81 talks about ROC to maintain register of charge. 85 says company has to maintain register of charge. For ROC, in the website they maintain register of charge, that register is sufficient. For company, key points to note here, the register of the charge with details of all the charges created should be maintained permanently. Only very important, it has to be maintained permanently. Instrument of charge, the proof of charge, that instrument is if you keep for 8 years, that is sufficient. This is 81 and 85. Next, 82 and 83 both relate to satisfaction of charge. What do you mean by satisfaction once the loan is repaid? 82 talks about company to intimate ROC for satisfaction of charge. 83 says if company does not intimate, company is lazy, then ROC will record satisfaction by themselves. When should you intimate ROC for satisfaction? Here the time limit is very simple. First they are saying within 30 days of property being released from company or property sold or company repaid the loan, within 30 days you have to intimate ROC as the loan is repaid. Otherwise they are giving overall 300 days, which is first 30 days plus additionally 270 days. So overall 300 days inclusive of these first 30 days. Whenever you intimate ROC, what ROC will do? ROC will cross check, and if there is no objection, so what ROC will do, since company told loan is repaid, they will cross check with the bank and they will ask the bank, wait for 14 days. If bank doesn't give any objection or bank is silent in these 14 days, then ROC will go and record satisfaction of charge. 83, where loan is repaid but nobody has intimated to ROC, then ROC by itself can record satisfaction of charge. By themselves they will record satisfaction of charge. Here, once they record satisfaction of charge, they will intimate the concerned parties, company and the bank, the charge holder and the lender will be informed about the same. If they have objection, then they have to come back. 84 is another simple section. Sometimes when company goes into liquidation, in the process of winding up, they may appoint official receiver or manager will be appointed. He is nothing but liquidator. Who will appoint these people? Generally the court will appoint, sometimes bank will appoint. Whoever appoints this official receiver or manager, all they are saying, the person appointing, the appointer has to intimate ROC within 30 days. Intimate ROC within 30 days. That's about it. Sir, what is 86? 86 is penalty. I'm coming in order, guys. So 84 is done. 81, 85 is register of charges. 86, in any of the filings in section 77 or in 79 modification or 82 satisfaction, anywhere if wrong information is given to ROC, then such officer is liable for fraud under section 447 if the same was intentional. Last 87 is condonation of delay. We have seen many time limits, within 30 days, within 300 days, within 30, 60 days. What if the time limit is crossed, sir? I still want to apply. Then whenever you apply, that from that period only the loan is treated as a secured loan. It's treated as a secured loan, guys. But till that period, the loan will be treated as unsecured, no retrospective amendments. But even though you're late, if you request the central government can condone the delay and accept registration even if it's after 2-3 years after loan. But only from that date of registration, it is treated as a secured loan. Lastly, rectification. Some mistakes in loan amount or interest or any documents or any data already submitted in 77 registration, 79 modification, 82 which talks about satisfaction. If there are any errors, you can again reach out to ROC where they will rectify. So this is in summary, guys, our charges chapter 77 to 87. All the GenZ notes are available in the description of the video in the link. You can go and download them. Ideally, I tell our students to make their own GenZ notes. Your own handwriting works for you. But if you don't have time for that, then you can use these GenZ notes, make some modifications to suit your handwriting, etc. Thank you so much, guys. Keep learning, keep growing.
Okay, hi guys. Now we are going to revise full meetings chapter 88 to 122 using our GenZ notes. Please refer to your GenZ notes. We will start off in the same order. 88 talks about register of members. What are the key points here for exam? Update in register within 7 days after any transaction. Where will I keep the register? Registered office. Can I keep anywhere else? Yes, you can keep anywhere else in India if company passes a special resolution and if 1/10 of members reside in that location. That is which section? 94. Okay. Anywhere else in India, and this register will be kept for how many years? 8 years. Other points in this, in the register, if there is any charge, lien, or if any security is enforced, you have to update in the register of members. If there is any death, insolvency, or any transfer to IEPF, that also will update in register of members. Last one, if the number of members are less than 50, then no need to maintain index. I hope you are able to recollect the points. That is more important than being able to tell all the points. Next, 88 subsection 4 talks about foreign register, which is same as Indian register. Only difference is, once you establish a foreign register, you have to intimate ROC within 30 days and then backup that should be sent back to the principal location within every 15 days. Signing difference, the CS and director will sign for both 88 and 88 subsection 4, but the difference is he has to append on every entry. Foreign register, every entry you will sign there, page wise, it's enough. Next, 88 over, then we went to 94 also. Again related to this, we are going in the same order how we took the class. 91, closing off register of members. Can you close? Yes, maximum 45 days. At one stretch, 30 days. Before closing, notice of 7 days. Perfect. Then we saw two sections, 89 and 90. BO and SBO, beneficial owner and significant beneficial owner. BO, they are saying, registered, what they are trying to say, the registered owner will intimate the company within 30 days when he appoints a beneficial owner in form MGT 4. Same way, beneficial owner also will intimate company within 30 days when he is appointed MGT 5, and the company will inform ROC within 30 days in MGT 6. This concept of BO is not applicable for a government company or a mutual fund or venture capital fund. Are you able to recollect, guys? That's it. Next, 90 also same thing, but here what they are saying, an SBO will intimate company within 30 days in form Ben 1. Registered will intimate company within 30 days when he appoints an SBO. They have not given the form number. Company will intimate ROC within 30 days. Who is an SBO? He has 10% or more of voting power or paid up share capital or getting the dividend or has control or significant influence. Any of the one. Then exception. This SBO is again not applicable to a government company. Additionally, central or state government and your mutual fund, venture capital fund and REIT. Two new points added in our syllabus here is Ben 3 and Ben 4. What is Ben 3? Register of SBOs. So company has to maintain register of SBOs open for inspection for 2 hours. Ben 4 is very important. If somebody is not reporting to the company, if company has a doubt, I can send them a notice asking them if they are an SBO. So notice to doubtful individuals in the last 3 years, even if you are not shareholder in Ben 4, if they are not responding to the Ben 4 notice, then you can apply to tribunal within 15 days. Are you following us? This is section 90. Then this were the procedures. So we finished 88, 89, 90, 91, 92, 93, 94, 95, except 92. We will come back to that in some time. Then we went to meetings. First is 96, which talks about AGM. What are the key points here? No need to mug up all. Like I'll ask questions, you will answer. Where will be the AGM? Registered office. Same city, town or village. What time? 9 a.m. to 6 p.m. I can start anytime between 9 a.m. to 6 p.m. Where can I keep anywhere else in India? Yes, if company passes a unanimous resolution. Which day can I keep AGM? Any day except national holiday. If it's government company, central government can keep it anywhere in India. Next time, AGM will be held within 6 months from end of financial year and maximum 15 months time gap between 2 AGMs and one every calendar year. You have to satisfy all the points. But if it is first AGM, instead of 6 months from end of financial year, they are giving time of 9 months from end of financial year. Next, ROC can grant 3 months extension. So 6 months can become 9 months, but extension is not allowed for the first AGM because first AGM already has 9 months. Section 8 company, time, place, date of the AGM is decided by the board of directors. One more thing for section 8 company, for AGM instead of 21 days notice, 14 days notice is sufficient. Next, 97, 98. 96 is again what guys? AGM. 100 is what? EGM. 97, 98 is tribunal to call for AGM. Tribunal to call for AGM. Even if one member attends, it becomes a valid meeting. Even if that one member is a proxy, we will consider as a valid meeting. Next, 99 is penalty for not holding AGM or EGM. Then EGM we will take in the last guys. We are going in the same order how it was taken for us in class. We can't go to EGM after 98, 99 because you should know about notice. So for every AGM, notice is mandatory. So 101 talks about notice. What are the key points here? No need to mug up all points. Notice should be 21 days before AGM. 21 clear days. That means date of AGM, date of sending notices not counted. If it's postal, additional 48 hours will be given. If it is less than 21 days, yes, you can give a notice less than 21 days. If 95% of members agree in writing or electronic mode, latest RTP question. Section 8 company we already saw 14 days notice. Such notice should be clear, explicit, unconditional. I can't give any conditions. Next, intentionally I didn't give the notice. Deliberate omission to give notice to any member makes it void or invalid. If it is not deliberate omission, genuine cases, then the meeting is valid. Company will prove with the postal challan. Then to whom the notice will be sent? Shareholders, legal representative of deceased, auditors, assignee of insolvent member, directors. Don't mug up, just think shareholders, directors, auditors. If shareholder dies, legal representative. Shareholder becomes insolvent, assignee of shareholder. Then the notice will of course have details of place, date and time. Otherwise it's not even a notice. Then we went to the important section for us, section 102. Explanatory statement. Let me revise this point again. In AGM, 4 businesses: adoption of FS, declaration of dividend, appointment, reappointment of directors, appointment, reappointment, remuneration of auditors. These 4 business are what guys? Ordinary business. For ordinary business we have only ordinary resolution. All other business in the AGM is called special business, and special business can be ordinary resolution, special resolution or unanimous resolution. In EGM, all business including those 4 business are called special business. What this section says, learn what is special business. AGM other than those 4, in EGM all business. For every special business you need an explanatory statement is mandatory to be attached along with the notice. What is explanatory statement? Giving more details about the transaction, with whom I am entering the transaction, how much is the transaction, party, all those details. Okay. Next we jump to section 114 because it's related to resolutions. 114 talks about ordinary and special resolution. Whenever you pass a special resolution or board resolution, you will intimate ROC within 30 days in form MGT 14. That is given in which section? 117. So resolution, special, board, intimate ROC within 30 days in form MGT 14. This will come in every point wherever you write about special or board resolution. Be careful, not for ordinary resolution. Then we jumped again back to meetings chapter, main core meeting, section 103, which talks about quorum. What are the important points? Exam ku what to remember for quorum. Private company 2 or AOA, whichever is higher. Public company up to 1000, 5, 1001 to 5000, 15, more than 5000, 30. People are personally present. We do not count proxies, but you will count representatives. Representative under 112 and 113. 112 we have 2 people. President, governor. 113 we have 3 people. Central government, state government, company. This representative is counted for quorum. Are you following, guys? Now, if I am representative for 4 companies, I will be counted as 4. Next, this quorum should be present within the first 30 minutes. If not, meeting will be adjourned. Secretarial standard recommends that quorum is present at the time of passing every resolution, not the act. Standards recommends that. Okay, next, if there are joint owners, you will count as 1. Will I count preference shareholders for quorum? No, but I will count them if they can vote. So in a meeting of preference shareholders or dividend is not paid for 2 years for cumulative preference shares, I can count them. Next, if the meeting is adjourned, when it will be adjourned for? Board will decide when the meeting will be adjourned if the quorum is not there. If board is silent, it is adjourned to next week, same date, time and place. In the next meeting also quorum is not there, then the members present will be quorum. For example, for my company I need 30 members, only 20 are there. It becomes the quorum. Then for the adjourned meeting you have to give a 3 days notice to all the members or publish in 2 newspapers. What if it is an EGM which members called, and EGM is adjourned because there is no quorum? No, that concept is not there. EGM cannot be adjourned when members call for it. If quorum is not there, meeting is cancelled. So adjournment comes only for AGM, and even for EGM if it is called by the board of directors. Next we went to section 104. Simple, chairman. What is important? Chairman has the power of casting vote. Second vote in case of a tie. Who will select the chairman? The board among themselves will select the chairman within 15 minutes as per articles. If everybody is okay, that chairman will continue. If somebody is contesting, no, I am not okay, then members can elect a chairman among themselves, but that members can protest only if they can demand for a poll. To demand for a poll, you need to have 1/10 of total paid up share capital, otherwise you can't demand for a poll. 105 again, big section. Proxy. What all we saw in proxy? Proxy can be proxy for maximum 50 shareholders, plus that 50 put together should be maximum 10% of voting power. If one person has more than 10% of voting power, then you can be proxy only for one person. What proxy can do? He can do only one thing: vote by poll. He is like a postman. Don't write that in exam. What he cannot do? He cannot talk. When I say he cannot talk, he can't ask questions to chairman. He can talk among themselves. Okay. He cannot vote by show of hands. 107 voting he can't do. He is not counted for quorum. And if member comes, then member will vote. Proxy cannot vote. For all of this we saw the logic. Here we are focusing exam points. What are the timelines for proxy? Before AGM, 3 timelines. 24 hours before, I can start inspecting who are the proxies. 48 hours before, you can appoint proxy. 72 hours before, you can request for inspection. That means I can request for inspection 72 hours before and start the inspection 24 hours before the AGM. Are you following, guys? Then if I appoint multiple proxies, who will be valid? Last one who is appointed 48 hours before AGM. After that I will not count. Next, proxy. Should he be member of company? Can be member, cannot be member. There is no mandatory rule over here. Is this clear, guys? Proxy important. 106. Who? It's not about who cannot vote. Somebody who is eligible to vote cannot vote if he has calls in arrears or there is a right of lien on shares. Are you able to recollect the points, guys? Otherwise revise and then watch this. Okay. Show of hands. Now section 107 talks about show of hands. For all resolutions you will do only by show of hands unless it is voted already under e-voting in section 108, or if somebody is demanding for a poll under section 109. That means already we saw you can demand for a poll in 104 for chairman, or you can demand for a poll in 107. So 109 has intros even 104 and 107 itself. Now coming to what is 109 poll. To call for a poll, you need to have 1/10 of total voting power or 5 lakhs paid up share capital face value, whichever is less. Any one irtha podu. Whichever is high means you should have higher. Any one 1/10 of voting power or 5 lakhs face value. Then you can demand for a poll. Once you demand for a poll, when the poll will happen? It will happen that time itself. If you are asking for two things, electing chairman, if you want for adjournment, because that should happen that time. So electing chairman, adjournment happens that time. Other cases, it can happen within 48 hours of AGM. Once poll is done, that scrutinizer will show the dabba, all of that key points. Within 3 days you have to give result. Within 7 days you have to give report. Report says how many votes in favor, how many against, how many not counted, all of that. Then we went to section 110, which talks about postal ballot. In certain cases or in certain resolutions have to happen in postal ballot. A few of those what we saw, the whole list is alteration of object clause, 27 variation of objects unutilized money, 43 rule 4 DVRs, 48 variation of shareholder rights, 14 alteration of AOA. In that, conversion of public to private or private to public, both are considered. Then section 12, shifting of registered office outside the city. Section 68, buyback. So if any of this happens, then you have to vote only by postal ballot. Then they're also saying postal ballot is deemed to have been complied if you are voting under section 108 in electronic voting. So no need postal ballot. Additionally, if you are a one-person company or members are up to 200. Here they are not saying private company up to 200. Can be private, can be public. If members are up to 200, no need postal ballot. If postal ballot needed, you can vote under e-voting. What is the timeline for postal ballot? Once you get the ballot, you have to reply within 30 days. Once you reply, all the from cutoff date, the last postal ballot, company should give report within 7 days and advertise 5 days before voting period is starting. What do you mean by voting period? The time when company starts opening all the ballot papers. Next to 108. 108 comes when postal ballot section itself tells it is enough if you do in electronic voting. Here only key timelines are important for me. If this is the date of AGM, you need to give report after 3 days and voting should be open at least for 3 days before AGM. In such a way, it closes at 5 p.m. before the date of AGM. Cut-off date should be 7 days before AGM. That means if you are a shareholder up to 7 days before AGM, it's enough. On that day, if you are a shareholder, you can vote. Then 21 days before AGM, you are anyway giving notice. When you are giving that notice, you should also publish in 2 newspapers that we are going for electronic voting, so people are aware. Is this mandatory electronic voting? Not mandatory for all companies, but if you are a listed company, that's it. You have to follow electronic voting. Or if your company has 1,000 or more members, you have to go. That means public company having more than 1,000, private can't have. Next to section 100. Now you can understand section 100 better because we finished notice. Simple. EGM, who can call for it? 3 people. Tribunal can call under section 98. Board can call by passing a board resolution. Shareholders can call if 1/10 of paid up share capital if they are calling. That means that same provision of 110, not 110. 109, that 1/10 of paid up share capital if you have, you can call. That means you can call for a poll, or you can call for EGM, or you can call for chairman for poll. All the same is 1/10. Where I will have EGM? Anywhere in India, not the registered office. Of course, first try registered office, not possible. Anywhere in India, we have many case laws for that. Which day? Any day except national holiday, just like AGM. Next, once they make the request, people making the request are called requisitionist. The EGM should be held within 3 months. Within 3 months, EGM should be held. First 45 days is for board. If board fails, then members will try to collect the details of members and try to conduct within the next 45 days. Any expense for conducting EGM will be reimbursed by the company. Are you following, guys? I will wait for the first 21 days. If no notice comes, then I will start initiating the process. These are the next, all the big sections. Then we saw some small sections. 116, very small. If a resolution is passed at adjourned meeting, it is treated as if it's passed on that day and not any previous day. That's it to remember for exam. 120. All documents and inspection required in this chapter, not act, in meetings chapter, can happen in electronic mode. Applicable, same 108 applicability listed, or any company having 1000 or more members. Next we saw 121, 122. 120, 121, 122. 121 important. For every listed company from date of AGM within 30 days in form MGT 15, you have to file a report of AGM to the ROC. This report will be signed by the same people who signed the FS in section 134. Chairman, if not chairman, two directors, where one is managing director and CS will sign. CS is additionally will sign here. What will be reported? AGM actually took place. What is the proof? When was the note? Give attached copy of notice. Attach quorum details. What resolution is passed? If meeting got adjourned, details of adjournment. Who is the chairman? Photos, documents will be filed to ROC for proof that AGM actually took place. 122 small section. OPC chapter is not applicable for. AGM is not applicable for OPC. But how will I pass resolution? Ordinary, special or board? I will intimate company, and company will just update in the minutes and they will sign. Are you following, guys? Then we saw two sections, 111 and 115. Both are similar. 111 is for circulation of members resolution. 115 is for special notice. Now 111, what they are saying, from the date of AGM, you can circulate a resolution if you give to the company at least 6 weeks before AGM. If you just want to give information about a business in the AGM, give it 2 weeks before. If you give it 6 weeks before, it gets added into the notice. Members can circulate resolution included as business. If you give 2 weeks before, only information. Again, for this circulation, you need to have 1/10 of paid up share capital. Same thing 115, special notice for two things. If you want, the retiring auditor shall not be reappointed. I don't like existing auditor, I don't want him first. Or appointment of somebody else other than the retiring auditor. I have nothing against existing auditor, I want somebody new. For this, you can again send a notice, special notice, for which you should have 1% of voting power, or 5 lakhs paid up value, face value, paid up value, whichever is first, 1% or 5 lakhs. Here you should send it between at least 14 days before you have to send, or 3 months before you should send. In this time gap you have to send. If I send before 3 months, it is deemed to be sent within 3 months. Once you send this 7 days before the AGM, the company has to circulate this to all the members. If they are not able to circulate, at least publish in newspaper and website. This is section 115. Are you actually able to recollect, guys? 3 months, 14 days, then above 6 weeks, 2 weeks, all of that. Okay. Next, 118, simple, minutes. What they're saying in minutes, I'll ask questions, you try to answer. Minutes are kept for how long? Permanently. Who has the custody? CS or director or any person authorized by the board. Where I will keep the minutes? Registered office. They have not given any provision to keep anywhere else, so I will keep it registered office. Separate register for each class of meetings, shareholder, debentures, all of that. Minutes will be numbered consecutively. Minutes should be signed within 30 days of conclusion of AGM or board meeting. Board meeting or AGM, within 30 days I will sign. Who will sign? Chairman only has to sign. If chairman is not able to sign, then board meeting means chairman of next meeting can sign. Reason? Because board meeting will happen soon. If it is general meeting, then director authorized by the board. If the chairman is not able to sign, death, then some other director authorized by the board will sign. This is 118. Here in 118, for section 8 company, minutes is optional for whatever reasons we discussed, confidentiality, all of that. Last section that we have actually revised all the sections. 119 talks about inspection of minutes. Inspection of minutes. Who can inspect? Only members can inspect. That too, they can inspect only for general meeting. Members cannot inspect for board meeting. When you can inspect? Business hours. Any 2 business hours you can inspect. Inspection, how much to pay? Free. If you want copies, you should get the copy within 7 days. For copy, company can charge maximum 10 rupees. Are you following, guys? But now section 120 says you can keep in electronic mode. Therefore, if the minutes are in soft copy, how much you will pay? Nothing. It is completely free. But soft copy can be given only for last 3 years. If company defaults, of course there is a penalty and tribunal you can apply to them and they will order the company to provide for the same. Are you following, guys? Let's revise the section numbers alone once from first. 88 register of members, 88 subsection 4 foreign register, 89 BO, 90 SBO, 91 closing register of members, 92 annual return, 93 not there, 94 place of keeping register of members, that 1/10, 95 register as an evidence. Then we saw 96 AGM, 97 tribunal to call AGM, 98 tribunal to call EGM, 99 penalty, 100 AGM. This is one set. Then we saw 101 along with notice you send 102 explanatory statement. Once you send both of this 103 quorum will come. Once quorum comes, chairman 104 will come. If the quorum is not able to come, you can appoint proxy. Why all of you are coming to vote? Who cannot vote? 106. Who can't vote? 4 types of voting. 107 show of hands. 108 e-vote. 109 poll. 110 postal ballot. Then some other miscellaneous sections. Here 111 circulation. 115 special notice. 112 representative of governor, all of that. 113 representative of company central government. Next to 114 special or ordinary. 117 file to ROC within 30 days. So 2 sets. Then one leftover section. 116. What is 116? Adjourned meeting, that resolution will be passed. Then 118 and 119 minutes, inspection of minutes. Then 120, 121, 122. 120 is documents in electronic mode. 121 listed company report on AGM. 122 OPC not applicable. Whenever we tell a section, are you able to recollect the provision? 20 minutes we revised meetings, but if you are doing it by yourself, a little more detailed, 45 minutes or 1 hour with our GenZ notes, you should be able to easily revise one of the biggest chapter. Are you feeling confident now, guys? Yes? No? Fine. Thank you. Yes. Okay, so basically what are GenZ notes? I want you to keep in the material, this is the first chapter we are doing GenZ notes for. Keep a separate notebook or last set of 30 pages for your GenZ notes. How to do it? For the full chapter, write it as short as possible. Okay, we are not fully done with dividend as of now. So some more concepts like interim dividend, all of that left. First we started off with 123. Put an arrow. You can write in any style, guys. Basically, write in a way, use arrows, symbols, abbreviations, short forms, long forms, whatever, that only you can understand. After 10 days, you should be able to understand. Your neighbor should not understand. If they understand, well and good. Okay. Every day I will review your GenZ notes in class. Some of them here already finished because they have attended class before. So they are exempted. They don't have to do it again. You just finish your GenZ notes. Those who are attending first time recording students, today if you are watching this recording, don't sleep until you finish this GenZ notes. So 123 is declaration of dividend. Yes. Sorry, start Panya. Yeah. Thank you. Keep reminding like this. Okay. Dividend. This dividend will be recommended by whom, guys? Board of Directors, approved by shareholders. Correct? I'm right. I'll just zoom in a little more maybe. Okay. Recommended by board, approved by shareholders. Such dividend will be paid in what mode? Only in cash through bank modes. Okay. I'm just going in the same flow what we discussed. So, approved by shareholders. This approval, can they increase? So, cannot increase. Cannot increase. That means it's understood it is, can be decreased. You can accept the same, you can reject. In other words, approval, you can reject, reduce. Are you following us? You can reject or reduce. Of course, this middle word is approval. I'm only writing the basic points, guys. 5 lines, half a side line you should be able to finish. So dividend recommended by board, approved by shareholders. All the approval points are done. Dividend in cash mode, banking channels. This dividend is paid to whom? Shareholders who are equity shareholders, or these kind of points we know don't have to write in Gen Z notes. Why? You know this. Even before you came to this law class, I'm sure you know dividend is paid to shareholders, equity, and unnecessary points don't write. That's why I wrote and erased. If you wrote now, you strike it. Okay. Don't write unnecessary points. It's the key summary points. Exam la kekava poram. Dividend is paid to which shareholder? You tell me if you're going to set the paper, will you ask this question? So don't put this in Gen Z notes. Unnecessary. Continue the line. Next. Okay. The same dividend, or right here down, whichever you can write in any, you can create however you want, guys. Sources. What is the source? Current year, previous year, combination, or guaranteed by government. 4 points in bracket. Current year, previous year, combination, government. Write short form CY, current year, PY, previous year. But you should remember that. Okay. Here key point will be what? For current year and previous year, reduce depreciation. I will reduce depreciation. Are you following, guys? Clear? Next. I hope it's visible. Visible for last row. Maybe I will zoom in little. Visible, assure. Super. Okay. Next. Next point is what? After source is done, we have to see if such dividend is adequate or not. If the answer is no, that means when will no come? If you're using previous year profits, if it is no, we split into 3 rules. That's it. 3 simple rules. What is rule 1? Average of last 3 years. That's it, right? In short. Then you can use 10% of paid up share capital plus. Don't need to write don't write rule name and all. I need the provision. And last one, balance of pre-reserves should be at least 15% of paid up share capital. Are you following, guys? Okay. Then these 3 rules are not applicable for a 100% government company. That means 100% owned by government. Are you following, guys? Clear? Anything else in section 123? We have some more points I'm yet to teach you that you can write here. Basically, reserves and surplus is only free reserves. Okay, that is one point. That's it. I will write in timeline. Timeline. Okay. Second point here you can write. In this itself you can write 10% minus current year loss, if any. Current. With the second rule it comes. Whatever you withdrawing in 10%, reduce with current year loss, if any. You have to make these notes, guys. In fact, I'm doing it little more detailed this time, because last time when some of the students made notes, avanike purila. I will review your notes in the class. I will ask you questions from that. Okay. Some students, they made the notes and they came, I asked them questions. They were not able to, what is this in Keta? CY. Sir, tell us, sir. So write only if you can understand and remember later. I will remember CY na current year for me. I will write in my language COY na company. But all these abbreviations of Gen Z notes, you should not write in. Remember, guys, don't use any of these APP na app vandrum apparama. Okay. I wrote approved. Later you should not ask, sir, what is this? Are you following, guys? Don't use these abbreviations in exam. I'm repeating. If you use this, your marks also will become abbreviated. I cannot help you that time. Okay. 123 is done. That's it. How many lines for this? How many lines it took you? 2, 3 or 4 lines? Okay, show your notebook. Yes, first row. Camera, I hope you can see it, guys. You should not be able to see. Anybody else? Yes, Varsha, where is yours? Show. Oh, it's full last time written. Okay. But this is the whole, that's it. Till here is the whole chapter. First 5-6 lines. Okay. 123 is done. Next is what? 124. Before I come to 124, let me finish the other small ones. 125 I yet to do. 126 is what? One line. Dividend, rights, bonus. If there is a dispute, will be kept in. That's it. Not even one line. Half a line. Half a line. 126 is done. 127. I am giving space so it's easy to copy. 127. If dividend is not paid in 30 days, then for company 18%, for director or officer, two things, up to 2 years plus 1000 per day. That's it. 127. This 127 not applicable, or in other words, exceptions ஒரே லைன்ல முடிச்சிடலாம். All the keywords. What is the first exception? Operation of law. Section 126 is an exception. Then lawfully adjusted instructions or directions given. No? Directions given and not. Okay, and communicated is the word. Whatever it is, it should be communicated and communicated. Next class I'll try to change the font. It's okay, not communicated. And last one, others. No, others the natural calamity, whatever. Okay, 5 points. That's it. 127 we have summarized in 2 lines. That's it. We have summarized in 2 lines. And lastly, 124, you just recreate that timeline in your note. You know the timeline already, so I will just recreate. 5 days, all inclusive, 30 days. Next, 7 days. Next, 90 days, all inclusive, 7 years. After this, 125 comes, correct? 125, which is IEPF. Let me fill in the values here. Within 5 days, separate. Within 30 days, you have to make the payment. Here, if it is within 7 days, if it is not paid or not claimed, and again, if you don't transfer within 7 days, you have interest at 12%. 90 days, what is the point? Summary report in website plus central government authorized website after 7 years, IEPF. That's it. Are you following, guys? You will prepare a timeline like this. This is what I taught you so far. We still have some provisions, Nidhi company exceptions. We still have interim dividend. I don't want to teach now. You're close to lunch. We will again come back and add to our GenZ notes. Okay. Are you following, guys? Okay. So if I just unzoom the whole thing, that's it. Here it looks little longer because I am writing it big for you to get zoomed. That's it. This is the GenZ notes of dividend chapter. Those who are watching recording, just pause, zoom in and read. I will just maybe zoom a little more. That's it, guys. This is section 123. Recording fellows, pause, just pause and copy. This is 126 to 124, 126, 127. That's about it. Are you all with me, guys? This will be here. You can copy till the end of lunch. We will go to lunch. One last time, let's revise section numbers. இங்க lunch சொல்றேன், recording ignore it. 123 declaration of dividend. 124 unpaid dividend. 125 IPF. 126 abeyance. 127 123 rule 3 rules. 100 EGM. 50 Calls in advance. 51. Dividend paid on nominal or paid up value. I didn't write 51 here because I'll put in share capital chapter of GenZ notes. If you want, you can write it here itself. Yeah, 62. Writes 63 bonus. So in the first session, we are done with almost remembering 10 section numbers. Any doubts? We will close, go for lunch. Thank you. Okay, back to our GenZ notes. This time we are going to revise accounts of company. Let's target to do as soon as possible. Okay, what are the important points for exam? You might have spent 2 hours, 5 hours, 7 hours for studying this chapter. For exam, what to remember? Quickly we will revise together. Loudly guys, I want you all to be very loud. Section 128 talks about accounts of company should be maintained in accrual basis, double entry. Can shareholders inspect? No. And it should be true and fair view for every year. Where will the books of accounts be kept? Only at ROC. Can I keep it anywhere else in India? Yes. By passing a board resolution, intimate ROC in 7 days and file form AOC 5. What can I keep books of accounts at foreign branch? Yes. If I have a foreign branch, books of accounts will be in the foreign location. Then you have to send summary returns on a quarterly basis to the registered office. Sometimes the director will ask for written request that should be given within 15 days. Who is responsible for maintaining books of accounts? We saw managing director, CFO and whole-time director in charge of finance. Then within books of accounts we saw, can the director inspect books of holding? Yes. Can the director appoint agent to inspect books of accounts of holding? Yes. Now same thing but with subsidiary. Can director inspect books of subsidiary? Yes, but company has to pass a board resolution. Can director appoint agent to inspect books of subsidiary? Yes, company has to pass a. Of course, inspection is only in business hours, so you can't expect night inspection. Okay. Next, within 128, we have some rule 3, which talks about electronic mode books are maintained. Now, what are the key points? Audit trail should be there. For that, backup should be there. Good backup, storage, legible form, printable and accessible. There should be some good security and firewall. It should be complete and unaltered. Okay. If you are altering, we should know who is altering, how they are altering. Very important. Server should always be in India, and for that you have to intimate ROC proof, IP address and name of service provider, address of service provider. If you are using any cloud service like Google Cloud, etc., details and address of the service provider. With this, we are done with section 128. Then 129, if you look at section 129, which talks about preparation of financial statement. What is financial statements including? P&L, balance sheet, notes to accounts, cash flow statements, statement of changes in equity. This financial statement should be in true and fair view. 133, if there is any deviation from accounting standards, you have to disclose that deviation. Next, we also saw for cash flow statement, for some companies it's exempt. They don't have to prepare cash flow, which is 1% company, small company, dormant and startup, exempted to prepare cash flow statement. Next, if financial year is incorporated on 1st Jan or later of any year, then the financial year can end on the same financial year or next financial year. Mostly if this happens, you will choose the next financial year, you will save cost. Next, 129, okay, foreign subsidiary. If I have a foreign subsidiary for the purpose of consolidation, if you are doing consolidation, dollar will be converted to rupees. Language should be in English. Financial year is different now. You will try to convert, if not get central government approval and do consolidation with different financial years. Okay. Next, we have a new concept called periodical FS in 129A. What to remember here? This is called limited review audit for any period which is not yet notified. Once you do this audit, inform ROC within 30 days. This is applicable for which company? Unlisted companies, not listed companies. Consolidation is mandatory, but some exceptions. Unlisted companies, one exception. Then ultimate holding, if they are doing consolidation. If H is doing consolidation, then S1 need not do consolidation unless H is in foreign country. You have intimated subsidiary in writing and they have not given any objection, then don't have to do consolidation. Next, 138 talks about internal audit. In internal audit, who can do it, guys? I want you to be loud. Who can do it? Anyone. Then that report will be given to management, appointed also by management. Applicability for listed companies, then unlisted public company limit is 200, 100, 50, 25. 200 is turnover, 100 is borrowings, 50 is paid up share capital, 25 deposits. For borrowings and deposits, it's not previous year, it's any time in the previous year. For private companies, same limits, but they have only 200 and 100. Are you following, guys? Then 133 is nothing, accounting standards. Then 130 talks about very simple, any person or statutory authority, SEBI, central government, RBI, if they feel something is wrong in a company, they will intimate tribunal. If tribunal feels company is operated by fraud or mismanagement, then they will reopen books for the last 8 years. Okay. Next, 131 is similar, voluntary reopening of books of accounts. Here, if the company wants to reopen board's report or financial statements, then they will pass a board resolution and apply to tribunal NCLT within 14 days. Tribunal will take its own time, get representation from 3 main people, central government, income tax department and original auditor, and they will pass one order. Once they pass the order, within 30 days you will intimate ROC by filing the revised financial statements and board's report. Can you keep revising whenever you want? No, only once in a year, and maximum you can do for last 3 financial years. 3 years over now you can't do revision, you have to apply to central government, different procedure, not in syllabus. 134 talks about signing off financial statements and board's report. Who will sign financial statement? Chairperson or 2 directors. One of them shall be a managing director, and CEO, CFO and CS if applicable, if they are appointed, that means applicable. Next, board's report, we saw other contents has lot of points like dividend declaration, related party transaction, loans, holding subsidiary details, CSR details, dividend details, risk, environment details, all of that. In that, key point was, if you are a listed or a public company with a paid up share capital of more than 25 crores, you have to do a self-evaluation, how I performed. And one more key point in that is DRS, Director's Responsibility Statement. Points are very key here. In that, first, accounting standards should be followed. If there is a deviation, disclose. Accounting policies should be followed consistently. There should be sufficient care for safeguarding of assets, then safeguarding of accounting records and detection of fraud. Going concern should be taken care. Laws and regulation should be followed. If you are a listed company, additionally, internal financial controls. Are you able to tell without seeing, or at least by seeing, I will recollect, guys? For exam, what are the points? Beyond this, they can't ask. Next, 132, NFRA, quickly. NFRA head office is in Delhi. What they will do? They will prepare accounting standards, auditing standards, and oversee quality of professionals. They will report to 2 House of Parliament. The committee includes 3 full-time and 9 part-time members. In that full-time, there is 1 chairman also. If any disciplinary action is taken, what is the penalty? For individual, 1 lakh or 5 times the fees, whichever is higher. For firm, 5 lakhs or 10 times our fees, whichever is higher. If a professional misconduct is noticed, they will be debarred from being a member for 6 months to 10 years. Name will be debarred. Then we saw 136, 137. 136 is before AGM, 137 is after AGM. 136 before AGM. 21 days before AGM, you have to circulate copies of FS and audit report to the members. If you want less than 21 days, yes, 95% of members have to agree. Same as section 101 notice. Electronic mode. This circulation should not happen physically. In electronic mode, mandatory for listed companies and public companies whose net worth is more than 1 crore and turnover is more than 10 crores. Why they use and here, where everywhere they use or? Because it's a mandatory condition. If you satisfy both, you have to circulate in electronic mode. Okay. 137. Once AGM is completed, you will file FS to ROC within 30 days in form AOC 4. If it's a 1% company, then they will file within 180 days from closure of financial year. Then in this, for some companies, they have an XBRL reporting, very important, which company listed and all their subsidiaries, paid up share capital of other companies more than 5 crores here, or turnover more than 100 crores, or companies following Ind AS. For some companies, XBRL not applicable. Bank, NBFC, insurance, housing finance. Once you follow XBRL, you have to follow for a lifetime, even if next year limits are not met. Then some more cases here. So what? We have to file 137 to ROC within 30 days from AGM. AGM held, normal scenario, AGM held, FS adopted, then file within 30 days. AGM held, FS not adopted, then you will file within 30 days something called provisional FS. Whenever you adopt it later, that time you file the final FS. Sir, AGM itself I didn't keep, sir. Could not keep AGM for whatever reason. No problem. File in 30 days from the date on which AGM should have been held and file with ROC as provisional FS. Whenever you keep the AGM and adopt the FS, that time you file final FS. This with section 137. Perfect. Then all sections are done. Then we went to CSR. Okay. Yeah, we went to CSR, guys. Okay. Are you following, guys? Last section 135, which is CSR. Follow. In CSR, let's revise one more time. CSR 135 is applicable for whom? It's applicable for whom? It's applicable for any company whose turnover is more than or equal to 1000 crores, net worth more than or equal to 500 crores, net profit more than or equal to 5 crores. How you have to spend, or how much you have to spend? 2% of average net profit of last 3 years should be spent. If I am loss making company, will I spend? No. Even if turnover is crossing limits. In this net profit, I will not include two things. One, income from an overseas branch or subsidiary, and dividend from a company already paying CSR. Now this 2% can be three extreme scenarios. One, I spent exact 2%. Good. I spend more than 2%. So if you spend more than 2%, I will carry it forward to next 3 years. If you spend less than 2%, they are deciding ongoing project or not ongoing project. Simple. Ongoing project, they are saying very easy way, spend within 3 years. In the 3 years, in the first 30 days, you will transfer to separate bank account. In the 3 years, if you don't spend, then in the next 30 days, you will transfer to fund under schedule 7. Not ongoing, project is not yet started, you are not capable. Within 6 months of end of financial year, again you transfer to fund under schedule 7. For all the spending, we need to have a committee called CSR committee, which is mandatory if the spend is more than 50 lakhs. For this committee, public company should have 3 directors if independent director is required for that company. Otherwise, 2 are enough. Private company, anyway we will have only 2 minimum, then I will have 2 directors. Independent director concept is not there for private company. Foreign company means you should have the person authorized representative under section 380. Next, a few other small amendments which are important. During CSR activity, if you created a capital asset like hospital, or you purchased the hospital, that should be registered either under a name of section 8 company or a public authority or a trust. Public authority means corporation, etc., or registered trust, or the beneficiaries for whom we are building the hospital or school. Next, which profit you have to take? PAT or PBT? PBT. Can multiple companies come together and do a project? Yes. If holding company is following CSR, should subsidiary follow? No. Apply limits for them separately. For other activities, administrative work, CSR expense can be maximum 5% of the CSR expense can be admin expense. Sir, where to spend? First, where you should not spend is important. Employee and their family. You can't spend outside India. You can't give donation to political parties, one-off events, marathons or awards or charity or any employee statutory contribution is not possible. But if you are doing charity, you want to donate. Donate to whom? Section 8 company who has a track record of 3 years of doing similar objects. Schedule 7, we have our story, but remember some key points: malnutrition, poverty, education, art, culture, then sports, Olympic sports, recognized sports, public library, then research for contribution for research, natural disaster, Har Ghar Tiranga, COVID, rehabilitation center, all these we can say, or let's say restoration of sites, all of that you can spend. Okay. Next, last 3 points in CSR. First time when CSR is applicable for the company, they have to register in CSR 1 for CSR registration. Second, CSR 2, you have to file AOC 4. Along with AOC 4, you have to file CSR 2 on yearly basis, giving details of all updates that happens. So while doing CSR, I didn't plan, sir, but I earned some profits. Those profits you also spend for CSR. If you are not spending for CSR objects, then within 6 months you will transfer to fund under schedule 7. Lastly, impact assessment. For whom it is eligible, if the CSR spend is more than or equal to 10 crores in the last 3 years, then I have to do an impact assessment. Then assessment is for whom, not for all the projects. If there is any project in the past which is more than or equal to 1 crore, which should also be completed, and that completion should have been 1 year over. I will again repeat, project over, completed, it should have been 1 year since the date of completion, and project is 1 crore or more. Then only I will do impact assessment, then only I can see the impact. For that, one professional is doing a independent agency, can be CA, can be not CA also. For him, the limit that they have given is 2% of CSR or 50 lakhs, whichever is higher. In that 5%, I will include 2%. That's it. Revision about CSR and a whole chapter following, guys. Okay. Perfect. Let's revise section numbers of this chapter. 128, books of accounts. 129, preparation of financial statements. 2 subsection 40, loudly. 129A, periodical FS. 130, reopening of books. 131, voluntary reopening. 132, NFRA. 133, accounting standards. 134, signing off board's report. 135, CSR. 136, circulation of FS to members before AGM. 137, circulation to members after AGM. 138, internal audit. That's about it, guys. Those who are watching recording, for remembering section numbers, write it 3 times now itself. At least half of those you will remember. That's it, guys. Thank you. Yeah. So let's start revising audit and auditors with our GenZ notes in less than 10 minutes. I gave you a few minutes time. We finished auditors today and yesterday. You went through the notes. Now we will revise together. Okay, we will start off in the same order in which the class was taken for you guys. 142 talks about remuneration of auditor. Simple. For statutory audit, audit fee could be inclusive or exclusive of travel, food and other expenses. Shareholder will decide this by passing a ordinary resolution. First auditor, board of director will decide the remuneration. That's all to remember for exam from section 142. Next we went to 145. 145 talks about auditor has to sign the audit report. If it's a firm, any partner can sign and he will give his observations and reservations in the report, can be read in the AGM. Important points, he will read it. Next we saw 146. Auditor has to, he shall attend the AGM and he also has right to speak and be heard in the AGM. Right to speak, he will speak. Heard means if somebody tells a question, he can answer. If it's not possible, authorized representative, instead of him, some other CA will go and attend. This is 146. Then we went to 144. In 144, we saw one set of people, A, cannot provide the services to another set, group B, if you are the statutory auditor. So 144, auditor not to render certain services. So who is that one set of people? If you are the auditor, that means if I am the auditor, myself and my parent, subsidiary, associate and some other entity in which my firm has significant influence or control, and any other trademark or brand name of my firm, we can't provide services under 144 to the company, then companies holding and companies subsidiary. What are the services? We have a mnemonic, this I cube. I am dupe. So basically investment advisory, investment banking, internal audit. AS, actuarial services. MS, management services. DS, design and implementation of financial information system. Outsource financial services. Other services. BS, bookkeeping services. Are you following, guys? Clear. Then we went to next section. 141 eligibility. Who is eligible? This we split the section into two parts: qualification, disqualification. Under qualification we have only one concept. Under disqualification we have four parts. Under qualification, who can be an auditor? CA as per ICA Act, or a firm where majority of CAs are practicing in India and the firm includes LLP. Then disqualification, the first part out of the four parts we saw. In first, you for with the company, and the company is holding, company is subsidiary of the holding, and very important, subsidiary of the associate. With this group you cannot have business relationship, but what is allowed is professional service as per ICA Act, like tax audit, GST audit, and commercial transactions at arm's length price na it's allowed. Examples: hotel, airline, telecom, etc. This was the first part. Second, then next we saw employee and officer of the company and their employees and partners. So employee, officer, their employee and partner not allowed. Then any person who is a director in the company can't be the auditor. Any person whose relative is the director or KMP in the company, then you cannot be the auditor of the company. Body corporate not allowed. LLP is allowed. Okay, fine. Next one. Third part we saw that limits for every partner, individual and relative. So individual's partner, individual's relative with the whole group. Here who's the whole group? First let's look at the group. Company, company's holding, company's subsidiary, company's associate, and subsidiary of holding. With this entire group, guarantee and security is maximum 1 lakh, indebtedness maximum 5 lakhs, security not for individual and partner, only for relative up to 1 lakh of face value. If it crosses, rectify within 60 days. Corrective action will be taken. Now we spoke about relative. Relative is defined in two subsection 77. In that we saw individual, first your close relatives, parents, kids, brother, sister, and spouse. Then everywhere stepfather, stepmother, everything will come. Brother, sister, step will not come in two places. You can't have step spouse, so step is not. That is one, logically not possible. Second is stepdaughter is not included. This you will remember, I don't have to teach you again also. And son-in-law and daughter-in-law. Next, then we move on to fourth disqualification. If you are doing the following services, you can't be an auditor. 144 services, auditor not to render these services. No COP. If you have COP, if you don't have COP, you can't be an auditor. That means you are in industry. Maximum limit is 20, but this does not include 1% company, dormant, small company, private less than 100 crores, and convicted for fraud means 10 years, not possible. Are you able to recollect, guys? Then we went to 140. 140 talks about resignation and removal. Resignation is by myself. Removal, 3 cases. I want you all to be loud, guys. Resignation. Once you resign, intimate company ROC within 30 days. Inform edit 3. If it's government company, intimate even C&AG within the same 30 days. Next, board is removing. Board wants to remove you. They will first pass board resolution and intimate central government within 30 days. Once the central government order comes, within the next 60 days, you have to pass a special resolution and give opportunity of being heard. That's it. Resignation over, removal by board over. Next, removal by tribunal. Tribunal can simply pass an order. If order is passed, then auditor once removed because of fraud cannot be audited for next 5 years. But in this, tribunal can do it by themselves or an application given by somebody else. But if central government gives an application to tribunal, then they have to give the order itself within 15 days. Are you following, guys? Okay. Next, removal by shareholders. Removal by shareholders. This is 140 right along with section 115. Special notice. A special notice will be given. Then if special notice is given, then in general meeting, shareholder can pass special resolution to remove the auditor by giving opportunity of being heard. This you will read along with special notice. Special notice, just to revise the provisions, it's 1% of paid up share capital or 5 lakhs of paid up share capital, whichever is less. In meeting chapter you will see that. Next, go to 139, 5% of total voting power. Yeah, 1% of voting power and 5 lakhs. Anyway, we are not discussing this part, so I will just leave all of this because this comes in special notice. Meetings, GenZ notes, I will discuss special notice. Auditors, you revise, that's it. Leave that part. Come to 139. appointment of auditors. We saw this also yesterday. In simple, first auditor and subsequent auditor for each government and non-government. Simple. First auditor for other company within, board will appoint within 30 days. I'll just connect here so you can see. Board appoints within 30 days. If board fails, shareholder will appoint within the next 60 days. But actually you should write 90 days from incorporation. So that 90 includes 30 days of board. Okay, next, government company. C&AG will be within the first 60 days. After that, same as above. Board within the next 30 days. If board fails, shareholder within the next 60 days. Are you able to follow, guys? Why actually it's 30 plus 60? Both put together is 90. To have an EGM, you need 90 days in section 100. Okay. Next, subsequent auditor, other company and government company. For other company, once you appoint, he has one term for 5 years and every year we will ratify. That means from end of first AGM to end of sixth AGM it keeps going on. For government company, in simple, forget the complications, he will be appointed every AGM. AGM I will keep appointing every year, but the provisions is within 180 days from the commencement of financial year and he will hold office till the end of AGM of that financial year. Are you all able to follow, guys? Are you able to recollect this? Okay. Then if there is a casual vacancy, usually if there's casual vacancy, board will fill within. But if the casual vacancy is because of resignation, then shareholders will fill within 3 months. Why 3 months? Why 3 months to fill? Because 3 months is 90 days. 90 days you need time to keep EGM. Okay. Next, the government. If it's a government company, C&AG will appoint within 30 days. If they fail, board within the next 30 days. What about government company resignation? Still same. Resignation split comes only for casual vacancy of other companies. For government company, only one provision. No members in 3 months. Government company resigned. C&AG 30 days. If they fail, board within next 30 days. Total reconstruction of firm. That means all the partners leaving, new partners coming. Is this casual vacancy? Yes. Not appointing the auditor itself. Is this casual vacancy? No. Not appointing is not equal to casual vacancy. Then in the same section we saw rotation. Rotation is basically individual will be for one term of 5 years, firm will be for 2 terms of 5 years, total is 10 years. After your duration gets over, you will not be auditor for next 5 years is the cooling off period. For whom it's applicable? Not for all companies, only for listed companies or unlisted public company with more than or equal to 10 crores of paid up share capital or unlisted private company more than or equal to 50 crores of paid up share capital. Borrowings or debt more than or equal to 50 crores for unlisted public or unlisted private. Not allowed, meaning within this cooling period you can't try to find loopholes like using brand name or same network firm or common partners or old partner and new firm. These are not allowed. We discussed detailed in class with logic all of that. Okay. Members may propose. Members can also tell. Members of the company will tell the auditor that within your firm you please rotate the partners. Don't send the same face every year. I'm getting bored. Okay. Next, last section we saw, last important section 143 talks about rights and duties of the auditor. There is one set of points for rights. Duties has 4 sets. Under rights, what are the key points? He has right to inspect books of accounts under section 128 and books of holding subsidiary associate. Then he has right to get all information and explanation, right to visit the branch. Then 142, right to receive remuneration. 145, right to sign. And 146, not attend. It is right to speak at the meeting. No, sorry. This is right to get notice. 145 is also right to speak. So right to sign, right to speak in AGM and also right to receive notice for AGM. That is 146. Then duties, we saw there were 4 types of duties. One is enquiries made by auditor, fraud reporting, government, other general duties. Enquiries, 6 enquiries mandatory auditor has to do. Enquiries about whether personal expenses are charged to revenue, whether investments are sold at a loss, whether entries are just merely represented by book entries, whether shares are allotted for cash, loans and advance. 2 points. Whether the loans and advance security is prejudicial to members and company and loans and advance shown as deposits. This also we saw. Then next, fraud reporting, simple. If the auditor during his course identifies fraud more than or equal to 1 crore, then within 2 days intimate board and audit committee, then they should reply within 45 days. Whether they reply or not, within the next 15 days you will inform central government. So they replied within 20 days itself. Then from that point, within the next 15 days you will intimate central government. Less than 1 crore government is saying I don't care, so just 2 days you intimate board or audit committee. Next, for government company, third duty, simple. Once C&AG you file the report to C&AG, audit report is given to C&AG, then within the next 60 days, if there is a need, C&AG can order for test audit or supplementary audit. Are you following, guys? Okay. Other reporting duties, some key points, list of points are there, key ones. If branch auditor means you will rely on the work of other auditor following SA 600. Caro reporting mandatory. Then 133, accounting standards complaint or deviation you have to see. Then give report on adverse remarks, SA 700 series you follow their saying. Managerial remuneration, you give your comments, is it computed properly? Then director's disqualification, just like auditor's disqualification I have to check. And 125, IEPF. Is IEPF transfer done properly? Audit trial is the new amendment we have. And 123, declaration of dividend is correctly done or wrong. New point we saw here was the company cannot act as an intermediate to receive or transfer funds to an ultimate beneficiary. Are you able to revise, guys? 147 talks about penalty, important penalty. That's why it's even entered our GenZ notes. Auditor penalty. Generally, if you make a mistake in the provisions of Companies Act for audit chapter, 25,000 minimum, maximum 5 lakhs or 4 times remuneration, whichever is less. I am an auditor, I will do fraud and apply intentionally. If you do 1 year imprisonment, 50,000 to 25 lakhs, which is 8 times remuneration, whichever is less. Additional liability, unlimited civil and criminal liability. Unlimited means all the damages you have to pay and arrested. Along with the partners will join you for criminal and civil, but partners will not come if they were not involved or they were not doing the fraud. It's not intentional by them, then criminal is exempt for them. This 147. Then everyone's favorite section 148, cost audit. In cost audit, key points, they classify into applicability into regulated sector and non-regulated sector. Regulated includes like petroleum, drug, electricity. Non-regulated tea, coffee, cement, defense, etc. Overall, for regulated, overall turnover should cross 50 crores in previous financial year and individually 25 crores. For non-regulated sector, overall should cross 100 crores, individual 35 crores or more. If yes, then the report will be, we'll come to that report. This cost audit not applicable for 3 people. SC said revenue from exports more than or equal to 75% and captive consumption, no need. Okay. Then appointment, he will be appointed within 6 months from the start of this financial year, that or 6 months from end of previous financial year. If audit committee is there, you will take their recommendation. Report within 6 months from end of financial year. That means appoint within 6 months from start of the year, report within 6 months from end of financial year. Once you give the report, you have to forward to central government within. How to remove him? Simply pass a board resolution. All the other provisions of penalty, disqualification applicable to an auditor is also applicable to a cost auditor and company secretary. That's about it, guys. Thank you. Hoping you understood. Yeah.